minute and then we'll get started. All right, I think we're going to go ahead and get started. My name is Kimberly Kay, and I'm the Managing Director with the Legal Insurrection Foundation. And I'm very excited about the event that we have tonight. It's not an area that we have ventured into much yet. And so I'm very excited to bring awareness of this topic and discussion of this topic to you, our existing audience, and hopefully to others who may be able to watch it either now or in the future. Question we always get, yes, this is being recorded. We will post it online in about a week or so. It takes us a little time to get things edited and up. I also want to apologize in advance that I have some kind of head cold happening right now, so I'm a little bit stuffy. I'll do the best that I can. But a couple of housekeeping things before we jump into this. We will take time to answer your questions after our panelist presentations. You'll notice that there's two ways that you can interact with us and each other. We have a Q&A section. Any questions you have for the panel, please put in the Q&A section. That's where I'll be looking for those questions to submit to our panel when we get to that part of the program. You can interact with each other in the chat section. We do ask that you keep it civil, keep it on topic. We never have an issue with these things, but it's just worth mentioning. So you're able to interact with one another there. We are a 501c3 nonprofit organization. We run a very lean operation, and so any donations that you send to us go directly back into doing work like this and ensuring that all of the education efforts that we provide remain free in perpetuity. So if you do find this program of benefit and would like to donate to this program or further programs, I'll be sure to put the link in the chat section, not the Q&A, for your consideration later. If you have landed here, I'm sure you've read the biographies of our panel this evening, and we're really excited to have them and really excited to welcome Amanda, who joined us 2 months ago. And I think we're going to have a great discussion this evening. And I'm going to go ahead and start by passing this to Professor Jacobson, who is our president, founder, and fearless leader.
Thank you, Kimberly. And this is one of those webinars where I'm actually looking forward to it because I'm going to learn something today, and hopefully everybody here will learn something. We do thank our guests for being here. Ujay, who is an attorney who is handling a very important case in this field, and we're glad that he'll be able to inform us of that. And Amanda, who I think will go right after me, who joined us September 1, and we're very excited about that. And so far, she's great, and we have very high hopes, senior researcher and attorney. And one of the things that we loved about her when we met her was she'll tell you about her experience with this issue and being the founder of the U.S. chapter of Keep Men Out of Women's Prisons. And that's just really captured us. I mean, that is such an important issue. I think the whole issue we're talking about today really goes to the foundation of our society. I mean, what do we mean to be a society if we're going to put men in women's prisons, or if we're going to put boys on girls' sports teams? You know, what sort of deconstruction of society is that? I'll just give you one little anecdote, and then I'm going to be quiet. Somebody who most of you will know, I won't mention names, but she tweeted it out, so it's not like it's private information, has a daughter who's like 8 or 9 years old and had been very kind of acting a little strange and concerned, and, for a couple of weeks. And finally, after a couple of weeks, they said, like, what's wrong? And she said, a couple of weeks ago, the teacher told us that you can be both a boy and a girl. And this was really troubling to the child. She didn't understand that. And the parents assured her, no, and you can't be both. And but that's the sort of thing. It's almost like a social experiment we've gone through the last decade, and it's got all sorts of ramifications. So I'm going to turn it over to Amanda, who hopefully you'll be seeing more of in the future, and let her describe, her experience and what the issue is there.
Thank you so much. I am going to try to share my screen in order. Oh, I'm being told sharing is not turned on. So I will. Whoop, now we're good. Okay. Sorry for this. Okay. As Professor Jacobson described, I was the founder of Keep Prisons Single Sex, the USA branch, which addresses issues about cross-sex prison housing and tracking of criminal records in terms of who's committing crimes, because sometimes even the crimes now are being recorded based on gender identity as opposed to biological sex, which is making a mess of government records. Today, I'm going to be talking about some background, how it came to be that mixed-sex prisons were enshrined in law, and some challenges to ending this practice, and a little bit about where we are with an executive order that President Trump 2.0 issued on his first day in office. Okay, so the path to cross-sex prison housing being enshrined in law actually started in 1994, where the Supreme Court heard a dispute amongst the circuits on what was the legal standard for deliberate indifference in regards to Eighth Amendment violations. And it so happened that the plaintiff in that case was an individual named D. Farmer, who in the parlance of the time and in the Supreme Court decision was described as a transsexual. And in this case, there was no mention about cross-sex housing. This wasn't a case about trans rights, transgender rights. The decision doesn't mention transgenderism or gender identity. And this becomes really plain within the case itself. The case described that plaintiff Farmer had at one point sought to be placed in a co-correctional facility, which is not being housed in a wrong sex housing facility, but rather there used to be facilities which were near one another, a men's unit, a women's unit, and they might share some daytime programming. And originally, that was one of the requests for relief being sought by Farmer, but those types of facilities no longer existed, and that was no longer being sought by the petitioner at the time the case was at the Supreme Court. So this was not an issue in this case. So a little strange that this is where we start, but I will share with you why. Not quite a decade later, Congress passed the Prison Rape Elimination Act, known as PREA. While there's no mention of transgenderism, gender identity in the act itself, it does discuss the Farmer case from a decade before. So that was one of the jumping off points for the Prison Rape Elimination Act to be introduced into Congress. But again, nobody was looking to be housed in the wrong prison at this point. The act was passed unanimously by Congress in 2003. And the goal of the act, which is kind of a bare bones act, was to prevent, track, and punish prison rape and prison assault. But it established no specific rules about housing or searching inmates. Instead, PREA left that to a commission and then to the Department of Justice to develop regulations, which they were going to describe as standards, PREA standards. But they're regulations like any other regulation. And again, no mention in PREA about gender identity, transgender, gender nonconforming, sexual orientation, absolutely silent on all of those issues. One important thing to keep in mind, though, is that one thing PREA did do was say, If there are states which fail to adopt the standards that are eventually developed, they will be dinged for federal funding if they do not comply with the standards. So there's a little bit of a hammer hanging over states in terms of compliance with the standards whenever they get introduced. So the commission that was established took 4 leisurely years to identify its proposed suggested standards, and then those were picked up by the Department of Justice. When the commission was doing its work, it essentially went around the country and held hearings to develop the standards. And on the issue of gender identity, which eventually came up in the hearings, they were largely hearing from trans activists on those issues. So some of the lobbying by those groups did make it into the commission's version of the standards. They then turned that draft over to the Department of Justice, who went through the notice process under the Administrative Procedures Act, which resulted in the standards being issued in 2012. For our purposes, this is the important regulation. And in item C of this provision of the regulation, which was how do we use screening information? So we've done a risk assessment of who's at high risk for being sexually abusive, who's at high risk for being sexually victimized, and how do we use that information? Item C here describes almost casually, because this is the first time this is mentioned in the regulation, that in deciding whether to assign a transgender inmate to a facility for male or female inmates, the agency shall consider on a case-by-case basis this, and this. So this is sort of comes out of nowhere, and it doesn't say anyone is obligated to do this, but it clearly says this can or should be contemplated based on an analysis of the inmate's health and safety. Note, there is nothing in here about the health and safety of those residing in the receiving institution. It is solely focused on the health and safety of the inmate claiming to be transgender. Also of note in this section is item G, which is an issue that often comes up when people are engaged on the prison issue in particular, which is why can't we just have a separate facility for them? Lots of states did. California in particular had a medical unit, which was for vulnerable inmates, which included inmates who identified as, it was a men's institution, inmate males who identified as women, and gay inmates and other vulnerable inmates. But these regulations made it impossible to maintain those facilities except in very narrow circumstances. So at this point, the door is now legally open for men to be moved into women's prisons. It's grounded in these regulations. And again, it has the bite of, if this isn't adopted by the states, they can be subjected to losing federal funding. Most states and territories took steps to comply. This is looked at on a regular basis on a really 2-year rotational system, more or less. The last information, which was from this summer, all but 8 locations are either in compliance or sufficiently on their way to compliance that they are entitled to full federal funding on criminal justice related issues. Some jurisdictions went further though, either by passing new laws or developing expansive policies. I'm going to hit on just a handful of those for purposes of illustration here. So one of the locations was naturally New York City. And in 2016, Mayor de Blasio issued this executive order, which described that for any single-sex facilities in the city of New York, which included bathrooms, locker rooms, living spaces, and was interpreted to include prisons and has since then, that individuals who identify as transgender are able to access those facilities consistent with their gender identity, regardless of their sex. Another jurisdiction which enshrined this into law was the state of Connecticut, who passed a new law related to correctional issues, which included that inmates who have a birth certificate, passport, or driver's license reflecting a gender identity, or who can meet established standards for obtaining a document, which can mean anything, that they shall be presumptively housed in a correctional facility consistent with their gender, regardless of their sex. Our last example is the most egregious one, and California will come up again later in this presentation. California passed a law in 2020, which went into effect at the very beginning of 2021, which provided that individuals who are transgender, non-binary, shall be housed at a correctional facility designated for men or women based on their preference, just their preference. That's what counts. And while we could spend the whole hour just talking about how different jurisdictions have defined transgender, I will share with you how California does, because it's interesting. California describes transgender as transsexual, two-spirit, mahu, non-binary, which can also include gender fluid, agender, without gender, third gender, gender queer, gender variant, and gender non-conforming, which again can mean anything. And it could be simply a man who has long hair or a man who likes to wear nail polish. That can easily be described as gender non-conforming. So this threw open the door in California to male inmates seeking to be moved to the women's prison. I'm not going to go through all of these, but I thought it was worth mentioning here, which is in the wake of the 2012 passage of the PREA standards and subsequent years, the activism turning to that, what had been gay and lesbian activism focused on marriage rights. Once that Supreme Court decision of Obergefell passed in 2015, they largely turned their attention to trans issues. So that impacted much of this litigation. There was a huge amount of money and legal activity directed there. Of all of these, I'm just going to mention the judiciary with some specificity and go through some examples of the judiciary being captured, because that has resulted in noticeably how some of the decisions related to medicalization, bathrooms, participation on sports teams, et cetera, how some of that has been talked about by judges. So we'll start with the first example here is New York. And New York has a judicial institute for state judges. This was a training event for judges on transgender litigants in the courtroom. And the main presenter of this training in 2013 was from the Sylvia Rivera Law Project, whose entire purpose is trans legal activism. That's who was presenting this training to judges. And these are some of, we have a transcript of this, if you're wondering where this comes from. This is directly from the transcript of this live training. And this activist trainer presented to New York State judges that the most important factor in these cases is gender identity, how someone identifies, and that under New York City law, if someone is denied access to a bathroom based on their sex, when their gender identity is the most important thing, that they will probably win the court case. Judges, I am training you that they will probably win the court case, and that they have a right to be in those locations. So that really is, prejudging is perhaps too much of a literal on the nose description of that, but it is really slanting how judges were being advised to approach these cases. For sake of time, I won't play this, but this is a recording of the Chief Justice of the Massachusetts Supreme Court, who was providing an introduction to what was then mandatory training in the state of Massachusetts for court personnel, including judges, starting in 2018. And here he describes that this guidance is to ensure that you, judges, other court personnel, are ready and able to interact with transgender people in respectful, affirming ways. And again, the issue here is the notion of that affirming is required, because under the legal theories espoused by the Sylvia Rivera Law Center and other trans activists, what is affirming is allowing people to lean on gender identity, regardless of sex, when they are attempting to access single-sex spaces, in seeking medical care, in participating on sports teams, etc. So here, again, the judges are being trained to approach cases for which litigants are appearing in front of them in ways which are affirming of those espousing a gender identity, providing them with particular benefits. By the way, he starts saying what his pronouns are, but it goes on a bit long. Also, Michigan. The Supreme Court of Michigan ordered all of the judges in the state of Michigan to address people by the pronouns that they prefer. Again, this can be a substantive issue of the litigants appearing in front of these judges, and they are slanting in advance that if someone says they're a she, you call them a she, even though what they may be seeking as a male is access to a bathroom. It makes it significantly more challenging to argue cases against accepting the gender identity as being the most important factor in a case. Here we have a Colorado District Court judge. So this is federal court in Colorado. And here this judge issues practice standards, including courtroom decorum. And among what should be observed in the courtroom is calling individuals by their preferred pronouns. Now we're going to come to not the last example of this. It could go on forever just with judges, but the most egregious one, which is an ongoing issue in California where an individual is being prosecuted for raping two female inmates. This is a man who was housed in one of the two women's prisons in California. He is being prosecuted for raping two of them. He has also impregnated at least another one. And the judge in this case is requiring that the prosecutors, in the course of criminally prosecuting this individual for 2 counts of rape, that the prosecutor refer to him by female pronouns. This individual is going to appear in our next slide as well. I'm just going to give one example of legal challenges to housing men in women's prison pre-2025. This was probably among the most significant of the efforts which were stood up. This was a case filed on federal constitutional grounds against the California law that we just talked about. This was originally brought in 2021. This judge sat on the case for several years and finally dismissed it, but permitted it to be refiled, dismissed it on technical grounds. So it was refiled in 2024. And what I'd like to just draw attention to is the box at the top right, where the pleading now has interveners. When this case was in its first iteration, after the initial complaint was filed, a number of men who were housed in the women's prison sought to be interveners in the case, describing that they had an interest in whether this law was upheld or not. They were permitted to intervene by the court. And you may notice that one of these interveners is Mr. Tremaine Carroll, who is the individual who is now on trial for raping 2 inmates in the women's prison. He remains on the pleadings. This case is still live, and it's still in front of a judge in district court in California. Okay, that brings us to the first day of Trump 2.0, when the administration issued this executive order on defending women from gender ideology extremism and restoring biological truth to the federal government. Among the many separate provisions on this issue has so many permutations. The issue about gender identity in terms of medicalization, in terms of sports, in terms of healthcare. But among the issues addressed in this executive order was the prison issue. And here the executive order describes that the Attorney General and Homeland Security are to ensure that men are not detained in women's prisons or women's detention centers. And here it notes through amendment as necessary, and here it cites a regulation. This is the PREA regulation that was highlighted earlier in this discussion. So there is some recognition that full implementation of this executive order may require amending those PREA regulations. Also included here, although I don't have that portion on a slide, a preclusion of prison facilities, incarceration facilities, providing medicalization based on gender identity for prisoners. That includes wrong sex hormones, cosmetic surgery like breast implants, facial feminization, castration, etc. That is a subject of litigation which resulted from the executive order. So right on cue, within days of that executive order being issued, there were at least 3 legal challenges to the executive order. 2 of them were filed within the month. A third was filed at the beginning of February. And there was some jurisdiction shopping here. 1 was filed in Massachusetts, 2 were filed in DC. They have now all been consolidated, so the distinctions aren't particularly significant. All of the plaintiffs were permitted to use pseudonyms, which is important because that means that someone like me, who's trying to dig into this stuff and get it out into the public, is unable to identify what crimes were committed by these plaintiffs, which can have some bearing on, at a minimum, the public's disgust at these men being permitted to be moved into women's prisons. What it also means is that we don't know what facilities they're in, which means that it is not possible for those who have been active in this area to determine whether there may be incarcerated women who have things to say about this executive order in support of it and what harms they feel have befallen them having been housed with these men. Obviously, the government knows where they are, but these women may not have been in touch with the government for them to know. While it looks like there aren't very many plaintiffs here, the cases were amended to add additional plaintiffs, so now there are a total of 19. So for every one of these cases, there were temporary restraining orders issued and preliminary injunctions, all of which put a halt to removing these men from women's prisons. Some had already been moved, they were moved back, and it also stopped implementation of the medicalization portion of the executive order. There have been now subsequent rolling 90-day preliminary injunctions, which are set to expire later this month, November 2025. So what is being claimed in these cases are basically the same set of facts. They have alleged some individualized specifics, but these are consistent throughout all of the plaintiffs saying some version of what's here above. Not safe in a men's facility, high risk of harassment, subject to strip searches by male correctional officers. I'm just going to note here that having these men now in women's prisons means that Now, female correctional officers who thought they were hired into a women's prison are now forced to strip search these men as part of their jobs. That they complain they're being forced to shower in full view of incarcerated men, which is now something the women who are housed with them are subjected to. And they experience worsening gender dysphoria, which can lead to increased rates of suicidality. And to that, I would just say it's a little bit of emotional blackmail on the judges here, that we have plaintiffs who are essentially threatening to kill themselves if they don't get their way. So what were all of these challenges claiming? They were claiming Fifth Amendment, Eighth Amendment violations of the Rehabilitation Act, which is the equivalent in the federal government of the Americans with Disabilities Act and the Administrative Procedures Act. What is before, let me just talk about each of those. The Fifth Amendment claim was really a due process deprivation of equal protection claim on the basis of birth, sex discrimination, transgender status discrimination. The Eighth Amendment claims were about the known and substantial risk they allege of serious harm if they're moved to the men's prison. The Rehabilitation Act was alleging that it was a reasonable accommodation because of their gender dysphoria to house them in women's prison. And the Administrative Procedures Act suggested that implementation of that executive order, without going through the public notice period to undo the regulations, was circumventing the correct process, which should be done in order to implement the executive order. Okay, so as I mentioned, the preliminary injunctions were granted and have continued on a rolling basis. The district court judge who eventually heard these cases didn't lean solely on the idea about safety of these men. The items I was quoting before, that they were alleging harms about being made to shower in the company of men or being subjected to searches by male correctional officers, this district court judge found that compelling. He said even if they weren't subject to physical or sexual violence, that these other issues were sufficient enough for him to grant the preliminary injunction to maintain them in women's prisons. And he described that that was appropriate simply because the mere homogenous presence of men for these trans-identifying men will cause uncomfortable dissonance. And it's hard to read these cases without at every juncture thinking about what is happening to the women in prison who are being housed with these men and what kind of dissonance they are experiencing, believing, that they haven't been sentenced to do their time in a correctional facility with men, and yet here they are. Okay, so oral arguments were heard on this case, on these consolidated cases, on September 5. And what the panel here is having to decide ultimately is just, what do we do with this preliminary injunction? And they also had a number of other procedural issues that took up the bulk of this oral argument. Some of them being alleged by the government, some being raised or addressed at least by the plaintiffs in the case. And that's really what they seem to want to talk about for the most part at this oral argument. So it was a little bit of a challenge to get a read on where this case might go. It might well be determined on some procedural issues. I would note that 2 of these judges are Obama appointees. The Senior Circuit Judge Randolph was appointed by Bush the Senior. And my guess is, given that the preliminary injunctions are set to expire at the end of this month, that they are going to try to get out their decision in advance of that. They seemed disturbed by the rolling preliminary injunctions and that the cases had not been moving forward substantively. So I'm unclear if they would be willing to uphold a preliminary injunction that at least one of them very strongly thinks isn't legitimate, just by basis of being re-upped over and over again. I will skip over the procedural issues just for the sake of time. I would mention this from one of DOJ's brief on the issues. They really do have their eyes on the prize about what's at stake here in their reference to protecting the privacy, well-being, and security of female inmates in federal custody. I should mention one thing too, which is that the organization Keep Prison Single Sex is not just for the sake of women. It is also an issue that there are men in men's prisons who don't want to encounter women there. And there was a case out of the Seventh Circuit where a man successfully objected to being searched by a guard, a correctional officer, who claimed to be a man when she was a woman. So this is not unidirectional. This issue is not unidirectional, although obviously there are additional significant other issues for women subjected to being housed with men. So before ending, I do want to highlight some of the stakes here that the DOJ is alluding to in the conclusion of that paragraph. And among the distinctions between the male population and the female population, particularly as relates to men who identify as trans, this is a report that the Department of Justice Bureau of Prisons produces. This was provided as a FOIA in response to a FOIA request. The yellow highlight here is showing that in the population of, this is the parlance of this document, male to female, so men who are identifying as women, over 51% of the men in that category, so that's 1,500 plus people, are in federal prison for sex offenses. And I would just note, this is federal prison, not state prison, so we're not talking, as trans activists often like to argue, these are not people in for mere prostitution or sex work. These are serious sex offenses. A lot of this is now in the current day electronic. It's distribution of child pornography or other serious sex crimes. To give you a comparison, the data highlighted in pink are the women who claim to be men, and only 7.5% of that population is in for sex offenses. When you look at the general prison population, all men, all women, that number is around 12 or 13%. So when we're talking about the universe of men who are moved into women's prison, they are coming from this cohort of who have this extreme sex offense. And just to really highlight that before I close out, I'm going to share with you 4 examples of men who are currently housed in prisons, and you can see what their sexual offenses are, what their offenses are. In California, this individual is in for rape, sodomy, false imprisonment, and torture. The individual in Illinois is in for murder, arson. He strangled a male cellmate with his bare hands, and he's housed in a women's prison in Illinois. This third individual is a serial murderer of women. He was on trial for murdering prostitutes in Washington State. He's in a women's prison in Washington. And then our last example was convicted for repeated sexual assault of his daughter. And he is housed in a women's prison in Wisconsin. So that concludes my presentation here. As Dr. Jacobson noted, I'm at Legal Insurrection. There's our website, and there's our X and Twitter handle. And a lot of this information can be found at the website for Keep Prison Single Sex, which I've included here. Thank you.
You want me to talk about.
Yes, I was
Okay.
just popping in to say that. You're
Yeah.
up. Thank you.
Yeah. So my name's Ajay Gupta, and I am litigating a case currently here in the Northern District of Illinois. But let me give you the lay of the land when it comes to uh, educational institutions, and in particular, uh, middle and high schools here in Illinois, and trying to keep biological males out of female only spaces in these schools. But before I do that, I just want to highlight that this dispute is an intensively linguistic dispute. Most of it entails debauching language. And if you think about it, that is really the only way a male can claim to be a female. It has to be a speech utterance. Because if a human is female, then every part of her body is female. And no matter what you can do to it, likewise, if a human is male, every part of his body is male. And no matter what you do to it, the male is not going to become a female. And that is why, as I said, the only way to transition is by saying you have. And if you see the people who are going to decide these disputes, if you see them, if you hear them using the language that is imposed by trans activists, then you know that they have essentially presumed the outcome. And I will show you exactly how that happened in the case that I'm litigating. But that is why they resist the term biological male and insist on using cisgender or cis male, which really is a term that comes out of chemistry and has nothing to do in this context. But anyways, going back to Illinois and to the Seventh Circuit. Now, the Seventh Circuit early on had decided a case called Whitaker, in which the Seventh Circuit allowed a biological female who identified as a male, allowed her access to male-only spaces in a high school, and did that on grounds of the Equal Protection Clause and Title IX. And then there was another case which involved several biological females also identifying as males who were granted access to male restrooms in high schools, and again on the ground that not allowing them to enter male-only spaces would be a violation of the Equal Protection Clause and of Title IX. In both of these cases, all of the plaintiffs had gone to great lengths to identify as male. Some of them had changed their names, some of them were undergoing treatment. And so in both of those opinions, the Seventh Circuit had said, look, there can be no question that these plaintiffs genuinely believe that they are male. So those are the two cases that the Seventh Circuit had decided in which the Equal Protection Clause and Title IX had been used affirmatively, as it were. Now, what's happened in Illinois is that the state of Illinois has come up with what it calls non-regulatory guidance. And so the Illinois State Board of Education put out this guidance in March of 2020. And that essentially says you don't need anything by way of documentation. You don't need anything by way of the student even consistently identifying with a gender. Essentially, if they ask for access to the single-sex space reserved for the other sex, you have to grant it. And subsequently, after a case called Hobby Lobby, which is out of the Illinois Second Appellate District, which followed Bostock, the Supreme Court case, the Illinois Department of Human Rights in December of 21 comes up with even more liberal guidance, non-regulatory guidance, which says pretty much that if there has to be any accommodation, it has to be given to, in the case of men coming into girls-only spaces, it has to be given to the girls who are uncomfortable by the presence of the biological male who seeks access. So schools and school districts are caught between a rock and a hard place. They claim, or some of them may be genuinely worried, that if they violate non-regulatory guidance from the state of Illinois, they will be subject to lawsuits. And consequently, they have essentially opened up all their single-sex spaces to anyone who seeks access to them. So there's a school district here in Will County, Illinois, and the high school there is Bolingbrook High School, where we brought this action as a class action, where this one male student who doesn't even present himself as a male, so leave alone consistently identifying as a male, has been granted access to female-only spaces. And when the named plaintiff, who knows him to be a male, encountered him and had a traumatic experience, then subsequently complained about it, the school said, well, if there has to be any accommodation here, it has to be granted to the girl rather than the boy being asked to use single-use gender-neutral spaces. So we brought this class action in the Northern District of Illinois. We moved for a preliminary injunction and a temporary restraining order. The court denied the temporary restraining order, and after extensive briefing on the motion for a preliminary injunction and oral argument on that, denied it. And the way it went was, in our opening brief, we made clear that this is not a case of a transgender student, as that term is generally understood. Because all the cases that have allowed either the Equal Protection Clause or Title IX to be affirmatively used have said, if transgender has to mean anything, it has to mean consistent, persistent, insistent identification with the gender of the other biological sex. And in this case, for a male to consistently, persistently, insistently identify as a female. And we said, this school district has not put out any articulable criteria before they grant access to biological males to use female-only spaces. So our ask was a minimum. All we said was they be enjoined from enforcing their policy until they can tell us what is it that they look at. And during oral argument, the school district's counsel said, no, you cannot put a legal floor on what constitutes transgender. So let me show you what we said in our opening brief, just briefly, and then what the court did, because if they're using the school and the school district's language, that the court has already decided how it is going to rule. So this is our opening brief. And right up front, it says, this is not a case involving transgender students. Instead, it is simply a case where a biological male has said, for whatever reason, that I be allowed access to the girls' restroom. The court never even addresses the question whether the student should be termed transgender, simply characterizes the student as transgender. And having used that term, the court is going to say, well, there is all this Seventh Circuit precedent here. This student is transgender, so this student has to be given access to female-only spaces. Now, the consequence of this is that it is entirely possible for students to have talked to school officials and come up with what they call their gender support plan and be given access to sex spaces of the other sex, and their parents not even know about it. And in fact, that seems to be what is going on in many cases. So, could my daughter encounter a male student in her bathroom or locker room in an Illinois public school? Absolutely. Males are being allowed into female bathrooms and locker rooms under the non-regulatory guidance from the state of Illinois. And it is entirely possible that a parent not have any knowledge, far less have given consent to this. Now, as I said, the Illinois State Board of Education put out this non-regulatory guidance in March of 2020. And that says gender preference is all that is required. But the Illinois Department of Human Rights then makes that access even more liberal after, as I said, an Illinois appellate court decided a case called Hobby Lobby. And again, in all of these cases, the plaintiffs had gone to great lengths to show that they were consistently, persistently, insistently identifying with the gender that is other than their biological sex. But using the same cases, Illinois state agencies come up with guidance that says you need none of that. All you need is an expressed preference to access single-sex spaces reserved for the other sex. So here's sort of the timeline of this this class action that we brought. And I'll go quickly to our reply brief. And in the reply brief, I pointed out, essentially, this is what's going on. A student comes to school officials, says, give me access to the single-sex space reserved for the other sex. Put it in my gender support plan. The school officials say, oh, this person is requesting access to a single-sex space reserved for the other sex. That makes this person transgender. And now we're going to give this person access because this person is transgender. It is entirely circular. There is absolutely no objective criteria that is required or presented to what amounts to a violation of female-only spaces pretty much at will. Let me show you how the oral argument went. And the court says, well, you know, they have a gender support plan. They've been granted access. And I point out that all of this relies on entirely circular logic. The term transgender is being used as a conclusory label. You have affixed this label on a student, and that allows this student to access, in this case, a biological male to access a female-only space. How do you justify affixing this conclusory label transgender? Well, they requested access, so they must be transgender. The school district official, the school district council, as I said, resisted being asked to put out any criteria. There is no legal floor that the school needs to require for a student to prove their gender identity. And to go back to what I said at the outset, this is essentially a linguistic battle. They throw around the term gender identity, but there is no identification. All there is a preference, a self-declared preference to use the single-sex space reserved for the other sex. Okay, now during oral argument, I pointed out that our named plaintiff had this traumatic encounter where she encounters somebody who presents himself as male, is dressed as a male, speaks like a male, whom she knows to be a male, in the girls' restroom. And the counter from the judge is, well, what if this were a girl interested in girls? Would she have experienced the same trauma? She's afraid to take her pants down because somebody's looking at her and she's saying it's because a boy is looking at her. I'm just trying to figure out, is there a presumption that there's only going to be a boy who would look at her like that, as opposed to there being a girl who might look at her like that? And again, toward the closing of the oral argument, the question is, what if this were another girl who may like girls? Now, this sort of line of questioning is totally oblivious to the history, long history of having single-sex spaces, especially female-only spaces, in educational institutions and even in work environments. The reason these spaces exist is because girls are extremely vulnerable when they are using restrooms. There may be girls who have been victims of sexual assault, and encountering a male in an enclosed public space can bring back serious flashbacks. And the reason we have these single-sex spaces, female-only spaces, is to protect girls from two sorts of assaults to which they're extremely vulnerable: voyeurism and exhibitionism. And for a court to be totally oblivious about that and to use the conclusively labeled transgender essentially to come to the outcome that it has decided even before beginning with any analysis, tells you what the state is currently. And finally, to rely on non-regulatory guidance, it's not even regulations, non-regulatory guidance from a state to dismiss an action brought on behalf of, or on the grounds of, federal constitutional and statutory law, because completely defies any logic. I mean, that would amount to saying, well, Brown v. Board of Education should have come out the other way because Kansas had, in that case, statutory law that required segregation. Okay, so I'm going to pause here and wait for questions.
Well, thank you so much to both of you. I mean, it's because of horrors like this that myself and millions of other people have chosen not to put their children in government schools. So, because there's no one protecting the children anymore. In fact, they're opening them up to all manners of predation. I think before I get into other questions, I think Professor Jacobson had a question or two
Yeah.
that he wanted to ask.
Yeah, I mean, and somebody did ask a similar question in the Q&A. Where is this going? Have we reached a turning point politically? Have we reached a turning point culturally? What do you each see as the next steps in this, Amanda, as to the prisons, and AJ as to schools?
As to prisons, prisons predates a bit the faddishness of this issue, and prisons is somewhat unique in that there's a book that was based on activists in the UK, And they said, we're going to go after the prisons first because it is so outrageous that if we can do this there, if we can create mixed sex spaces in prison, there will be no justification for not doing this elsewhere. So the activists actually targeted prisons as its sort of first, victims. And so there is obviously a fad element to this. There is that interesting study that came out recently in terms of the lessening numbers of trans identification of young people. In some areas, sports, for example, medicalization, it seems as though we are on a path towards that being curtailed. I don't know that the prisons will naturally fall in line. It is a population that is, you don't kind of win brownie points talking about incarcerated people. There's a lot of not feeling terribly sorry for them by the general public. So among all of the areas where this may wane, I think prisons are likely to be the last, if at all.
I can talk about schools and where it may be going in schools, and especially the Seventh Circuit. Now, there is a split in the circuits when it comes to reading the term sex in Title IX. The 11th says it means biological sex. The 7th and the 4th have said it means social sex. But after the Scarametti opinion, the 7th on its own has asked for rebriefing and re-argument on that issue in a case that had been previously decided. So the 7th vacated its opinion on its own motion and asked for rebriefing. It is entirely possible that the 7th may join the 11th and say the term sex in Title IX means biological sex. So as I said, there is already a circuit split. It is kind of irrelevant what the 7th does. It has to be decided by the Supreme Court eventually.
Did you have any other questions, Professor?
I'll wait till we take other ones.
Okay. I mean, how widespread is this issue? And I think I would first ask Amanda, because as you just mentioned, the issue in prison kind of predates some of what we've seen going, I guess what I would call more mainstream with the education system, the public education system. How widespread do you believe this issue is in the prison system?
There are states which, in the wake of PREA, as I mentioned, have passed laws about this. There are even more states and jurisdictions that developed bureaucratic behind the scenes policies that can be very difficult to tease out. The challenges that Jay is describing about these sort of guidance, not wholly enshrined and available. That's the case in a number of states. In terms of the sheer numbers of men in women's prisons, it is not possible to find this out because in addition to there being 50 state systems on top of the federal system, and then over 1,000 municipal jail systems, which have, a continually changing population. Many states and most of the jails do not provide complete or any responses to public records requests. So the numbers are impossible to come by. One can only guess if for state systems, the best estimate, and again, these are imperfect because we know there are men in women's prisons or states where they won't answer this. It is most likely in the range of upwards of 200 throughout the country when you take all of the states together and you add the federal prisoners.
It's extremely widespread. It is worryingly widespread in schools. I haven't come across a single school where this is not an issue, even in middle schools. It's as I said, worryingly widespread. And initially, the foot in the door, if you will, was when girls who identified as boys and had gone to great lengths to say, oh, yeah, we do identify as boys, which is a much more sympathetic case, were granted access. And then it doesn't take long from there to say, well, then boys should be given access to girls only spaces. Okay, then what do boys have to do to be given access to girls only spaces? And it would be even more horrific if one were to require that, they have undergone some sort of treatment before they can be given access. Being female is not a prize that you get for making an effort, right? And so the slide down is pretty easy to foresee. Now, all you have to do is say, I want to go into the girls only space. And given the guidance in the state, there's pretty much nothing that the school district or the school can do.
Do any of these regulations or policies, I'm thinking particularly with regard to schools, but in general, distinguish the levels of privacy of the space? Is the shower open to everybody?
The guidance out of Illinois is pretty clear that they have to be given access to whatever space they demand. And that's what made this case a little more bizarre, is that this student had been initially given access only to the girls' restroom and not to the locker room and not to the changing room. But then, once the administrative complaint was filed and once the school had to review it and state its reasons on the record, they insisted, in fact, that once access is given to a quote unquote transgender student, that access is to all the spaces: restrooms, lockers, changing rooms, showers, all of it.
Just horrifying. I know the second time I've used that word. That's the only thing I have when it comes to this issue. I mean, go
we've
ahead.
dealt a lot with, call it roughly, the parents' movement through our criticalrace.org website. We got involved. Is there anything parents can do?
Yeah, so parents, when they come forward, we other groups have tried to file complaints. This, as far as I know, the case we filed here was the first one, which is trying to use the Equal Protection Clause and Title IX defensively, which is what they were initially intended for, right? To save the female-only spaces. Thus far, these constitutional and statutory provisions have been used offensively for biological males to access female-only spaces. Short of a lawsuit, I don't know what parents can do. I mean, parents do complain, and they're given the runaround, and then schools say, well, our hands are tied by the state guidance on this issue. There's nothing else we can do. Oh yeah, what we can do is give your girl access to a single-use gender-neutral facility if that's what she wants. And in fact, that is what the court said here is a perfectly acceptable alternative. So why do you want a preliminary injunction when Mr. Gupta, your plaintiff, can use a single-use gender-neutral facility?
But of course, if you said we're going to make a single-use facility open to the male student, they would say you can't do that, right?
Exactly. But that's the point. And it is not a practicable solution, right? Because not all girls can be accommodated in those single-use facilities. So where it is going essentially is, kind of pushing girls out of all of those spaces. Girls who are uncomfortable, will try to avoid restrooms in those parts of the school where they think they might encounter the boys they know have been given access. They will not change for PE. They will, come to school using already attired in PE clothes, so they don't have to use the changing rooms or the locker rooms. That's exactly what's going on.
It's awful. So I know that we've seen some activism, at least in women's sports. Riley Gaines comes to mind. I would think this would be a clincher for women's activists and women's rights group, especially when culturally we're seeing men named as Women of the Year. I mean, this stuff is everywhere. Um, do y'all see that as being at all beneficial, or are there groups even actively involved in trying to fight this on behalf of either the prisoners or the children?
The judge asking those questions to me, which I thought were demeaning, was a female judge.
No, I
So
completely agree. I completely agree.
Related to that, I guess the term feminist might be a little outdated. Okay. But where are the feminist groups that burst on the scene in the 70s and 60s? Where are they now? What are they doing? Anything to defend women in the 2000s?
So the legacy women's rights groups are uh, all advocates on the other side. They have absolutely bought into gender identity. I will share that one of the attorney groups representing all of the plaintiffs in the current case before challenging the executive order is the National Center for Lesbian Rights. The National Center for Lesbian Rights are the legal representatives of the plaintiffs who are men trying to access women's spaces. There are a handful of women's groups on both the conservative side, IWF is one of them, and a number of groups on a more progressive liberal side who are newer groups who have sprung up, several of them directly and specifically in response to this issue. But they don't get the attention of the media, they don't get the funding, they don't get the attention, they're not able to stand up lawsuits for the most part. One of them is the one who stood up the lawsuit in California, so they were able to do one, but they're simply outgunned by the legacy women's groups who are all in on this ideology.
yeah, I don't know that they are all in. I think one or two are all in, and the others are too afraid to speak up.
Which we see all the time with the
Yes,
cultural pressure. But
yes.
no one wants to be the one to be canceled. No one wants to be the first one to stand up and say, hey, have we thought this through? Like, if we say this out loud, this is objectively insane that we would be doing these things and making allowances for such behaviors. Um, I think with that, given time, I would like to, I guess, give each of y'all a few minutes just for closing statements, and then we will go ahead and wrap up.
Um, all I would say is if someone's a parent who thinks their girl has been, you know, deprived of what truly is use of a female only space, or has had to compete with a biological male and has been deprived of what she should have rightly been, the position she should have rightly obtained, please reach out. Because the problem with lawsuits is we need real plaintiffs. Article 3 standing requires real plaintiffs. We can't sue on behalf of you guys. Someone has to muster up the courage to come forward. And if your daughter has been deprived by this gender ideology of anything, come forward and allow us to bring an action. Well, that would be my pitch.
And on the prison issue, my closing point would be to simply share the information that it is not hyperbole that there are men in women's prisons throughout the United States. It is so outrageous that I think until people encounter this, they find it very hard to believe it's occurring. And that goes for the prison issues, sports issues, et cetera, that it seems so outlandish that people need to be made aware this is real. Just because it's not being reported in most mainstream press doesn't mean it's not occurring. So to share webinars like this one, and to make the data and information aware that it's happening so that people do know there are places they can go, like to Mr. Gupta, if they are experiencing it.
Yeah, and we can bring the action anonymously. So all you have to do is come forward and, for your daughter and for you to be willing to serve as plaintiffs, because without that, we can't bring an action.
Yes, absolutely. I mean, it's always something that I always encourage people that, and I've done this for years, but as I mentioned, I think the last time we did this, the situation is incredibly dire, not just with this issue, but culturally across the board. If you are able to stand up and make a difference, someone has to. We can't keep waiting for someone else. We need plaintiffs. That's not just for Mr. Gupta, that's for cases that we're involved with on the Equal Protection Project. And I understand why no one would want to be a plaintiff. There's tremendous risk involved, but we have to be able to take legal action in order to push back against the systems that keep allowing this, because there is very little legal challenge to this thus far. And your help is crucial. You or other people you know, if we can just get the word out that there are remedies available, if people would be willing to stand up and push back in whatever way you can do that. Like, you have to do that. So just to encourage you, we don't like to just complain about an issue. We want to equip you with how you can be involved in being part of the solution as well. So, and I did not ask you, Bill, if you had anything to say in closing. I'm sorry. I
That's
just jumped
okay.
in and cut you off. I'm sorry.
That's okay. Yeah, no, I just want to thank our two speakers here. I found it very informative. I think it's something that maybe we'll continue to look into. And it's a cultural war in many ways, and it's also, to me, a sanity war. I mean, how did we get here? I mean, that's what's so insane. And it's pervasive, and if you're not willing to fight for your daughters, then who are you going to fight for? Or your spouses or your sisters. And I think this mostly is a male in women's spaces issue. It's not a women in male spaces. That's really what it's about. And if you're not willing to fight for, the women in your life, whatever age they happen to be, I mean, why are we here? And so this is really a super important issue, and I'm thrilled that we got to talk about it and with two very knowledgeable people. So thank you very much.
Yes, thank you so much for your time and your expertise and your preparation and your willingness to discuss this, not just with us, but with our audience. So we greatly, and thank you for the work that you're doing,
Yes,
which is
that too.
tremendously helpful. And I'm always encouraged when I find out that there are people so deeply entrenched in issues that we're not, because we can never only cover so much space. So very grateful for both of y'all. And I
Great.
and I think with that, we're going to wrap up this program. As I mentioned, we will be posting this to the Legal Insurrection website, usually in about a week, and that's legalinsurrection.com. And we thank you for joining us and wish you a great rest of your evening. Bye-bye.